Hello, my name is Dennis Borden. I'm an Illinois attorney who concentrates his practice in real estate law and also a member of Main Street's Broker Lawyer Committee. I would like to spend a few minutes talking about issues with condominium association documents in real estate transactions. I'll discuss what documents are required to be delivered under the current version of the multi-board sales contract, and then talk about the responsibilities among the parties to the contract concerning the documents. Let's talk first about the copies of condominium documents that are required under the multi-board contract. Paragraph 15 of the 6.1 version provides that the seller shall, within 5 business days of the date of acceptance, apply for those disclosures described in the Illinois Condominium Property Act and provide them in a timely manner. The Condominium Act requires that the association furnish the information within 30 days of the written request. There are 9 types of documents and information to be provided by the seller under Section 22.1 of the Condominium Act, including a copy of the declaration, bylaws, other condominium instruments, and any rules and regulations, and a copy of the Statement of Financial Condition of the association for the last fiscal year. These 9 documents and information are referred to as the 22.1 disclosures. Although the Condominium Act anticipates that the Board of Managers of the association will provide the requested information to the seller, it is actually the association's management company that provides this information. Once all the disclosures are delivered to the buyer has 5 business days to determine whether the existing improvements to the real estate are in violation of existing rules, regulations, or other restrictions, or that the terms and conditions contained in the documents would either unreasonably restrict the buyer's use of the property or would result in a financial obligation unacceptable to the buyer, and accordingly terminate the contract by giving written notice to the seller. One of the first issues we face is the question of who is responsible if important information about the association or the seller's missing information, or the seller is missing information from the disclosures delivered to the buyer. For example, what if the management company didn't have copies of the latest recorded amendments to the condominium declaration or the latest version of the rules and regulations? Part of the answer to these questions was given by the Illinois Appellate Court in 2004 in an opinion that held that disclosures are prepared by the association for the seller and not for the buyer, even though it's anticipated that the buyer is going to rely on those disclosures as an important part of the buyer's decision to proceed with the purchase. The seller also assumes that the disclosures are true and complete when the seller delivers the documents to the buyer, but how many sellers review the disclosures to determine that they are complete and accurate before they're delivered to the buyer? Even assuming that the seller is using a real estate broker and an attorney in the sale, does the seller ever ask for assistance in determining the completeness and accuracy of the disclosures? And then there is the corollary question of whether it is within the scope of a real estate broker or attorney's expertise or professional responsibility to assist the seller in making that determination. Perhaps an even more important issue arises on the buyer's side. Obviously, it's ultimately the buyer's responsibility to thoroughly review and understand the disclosures. Does a typical buyer have adequate knowledge of the operations of a condominium association to determine that the association is in good financial condition and has adequate reserves for replacement or repair of the association assets? Does a typical buyer rely on their broker or their lawyer to tell them that there is something in the disclosures that the buyer should be concerned about? Has the buyer's broker or attorney agreed to review the disclosures and advise the buyer accordingly? Does the buyer's broker and or attorney even know what the buyer's present and future intentions for the property are? For example, if the buyer is becoming elderly and intends to ultimately put the property up for rent if they move into an assisted living facility, would a prohibition or limitation on rental units in the association have an impact on the buyer's decision to proceed with the purchase? If the buyer has a pet or intends to get a pet, would restrictions on pets affect the buyer's decision? There's also the question of whether a buyer is just relying, justifiably or not, on their broker or attorney advising them as to whether the association is in sound financial condition and will probably be so in the foreseeable future without significant special assessments which may cause a strain on a buyer with a fixed income. I know that this discussion probably raises more questions than it answers, but we as real estate professionals should remain acutely aware that condominium documents contain information vital to the buyer's informed decision and must be regarded accordingly. Thank you.